So now, with the two top Kenyan leaders having dates with the ICC, what are the possible scenarios after the ruling today made by the appeals chamber? Well, first, it is possible that the decision on Ruto's attendance of the trial may embolden Chief Prosecutor Fatu Bensouda to appeal the recent decision which allowed President Uhuru Kenyatta to skip most of the sessions during his trial. The second scenario is one where the appeals chamber may reverse the decision on skipping some sessions. Some consider that Uhuru's allies may convince him to snub his trial if this happens, citing his constitutional obligations to Kenya. Well, the other possibility is now where the UN Security Council may allow Uhuru's case to be deferred, but the complication for the Jubilee government here is that the Ruto case may have to continue unless they both receive a reprieve from the UN. Well, the final scenario, as you can see on our graphics, is if the UN rejects the plea for a deferral, and so Uhuru's case will have to continue. Well, this means Uhuru and Ruto will have to simply interchange fights and places at the ICC as they attend their trials, which they have been promised will never coincide. All right, so now we've seen that the appeals chamber at the ICC today accepted Fatu Bensouda's appeal that Deputy President William Ruto should attend most of the hearings for his case. However, if you recall, it's a different scenario for President Uhuru Kenyatta, as he does not have to physically attend his hearings. And joining me from our City Center studio is the victim's lawyer in Uhuru Kenyatta's case, Fogel Gaina. Sir, if you can hear me, great to see you. What is the implication of Uhuru Kenyatta not having to attend most of his hearings?
Well, the first thing to keep in mind is that the decision made by the trial chamber in the Ruto case and the decision made by the trial chamber in the Kenyatta case is in almost identical terms. Today's decision by the appeals chamber strictly applies only to the Ruto case, but I think all the parties will accept that that guidance applies to all cases before the ICC, including the case of Uhuru Kenyatta. So it may be that we have to go through a couple of procedural steps. One of those is known as reconsideration. Another might be an appeal in order to straighten out the procedure. But I don't think anybody will be any doubt that today's guidance by the appeals chamber will apply in the Kenyatta case.
As the victim's lawyer, what problem do you have with President Uhuru Kenyatta, attending to his trial through video link? You have to consider that this is no longer a personal interest, but we have national issues inclined here.
Yes, the victims have made their position very clear and strongly to me, and I have relayed that position to the court, and they certainly think that every accused person should be treated equally. It doesn't matter if you're a bus driver, it doesn't matter if you're a farmer, it doesn't matter if you're the president of Kenya. You should be treated equally before the court, and that guarantee of equality exists in the Rome Statute. Now, for that reason, I've told the court that the victims are totally opposed to the use of video link, and they are totally opposed to the absence of the accused from the trial chamber during the trial. It's important to keep in mind that today's decision by the appeals chamber is in fact much more flexible perhaps than it might appear. The appeals chamber has left the door open to the accused to make an application to be absent for exceptional circumstances, and the appeals chamber quite deliberately, I think, has decided not to define what those exceptional circumstances might be. So both Mr. Ruto and Mr. Kenyatta will be able to make applications to their respective trial chambers during trial to be absent for certain eventualities, and it will be up to the parties at that time to make submissions to the trial chamber and for the trial chamber to rule upon it. But it is in fact quite a flexible and pragmatic decision, I would say, in many ways, and it's certainly far more liberal than any other decision that has ever been made in any international criminal tribunal against any other accused person. So I think it's important to keep in mind that it is in fact quite an accommodation by the appeals chamber.
Well, is this the only way, the presence of Uhuru Kenyatta and William Ruto at The Hague, is this the only way that victims can get reprieve?
I think victims would welcome justice of any kind. They've been waiting nearly 6 years since the crimes have taken place. There have been no prosecutions whatsoever in Kenya against high-level suspects. There have been no prosecutions whatsoever against mid-level suspects. There have been no prosecutions against police for crimes committed during the post-election violence, and just a handful of prosecutions of direct perpetrators for the incredibly brutal crimes that took place during that period and that everyone acknowledges took place during that period. So they have certainly been waiting patiently now for justice of some kind, whether in Kenya or at the ICC. Now, if the trial has to take place with occasional absences by the accused from the courtroom, I think the victims will be able to live with that. But we certainly do need to get the trial to start on the 12th of November, as you mentioned. We've seen today, as you mentioned earlier in your presentation, that his defence team has filed yet another request to delay the start of trial. This request, as I've told the court before, falls within a strategy of delay, and more delay. And they will continue, I think, to pursue that strategy, and the trial chamber will continue to receive submissions about that, and they can rule when they've heard those submissions.
Maybe finally, very quickly, Kenya has applied for, a deferral from the UN Security Council. I mean, what happens when Kenya is granted that sort of deferral?
If Kenya is granted that deferral, then the trial will be suspended for a maximum for 12 months. The request has been made in terms that apply to both cases, that is to say, both the case of Mr. Kenyatta and the case of Mr. Ruto and Mr. Sang. So it would effectively suspend both of those cases for 12 months. They would then have to go back for a renewal every 12 months to the Security Council. It's important to keep in mind that there are 5 members of the Security Council which can veto any of those resolutions. Those 5 powers are the UK, the US, France, Russia and China. So essentially, Mr. Kenyatta and Mr. Ruto are placing their futures very much in the hands of those 5 powers if they decide to pursue their request to the United Nations Security Council.
Thank you very much, Fergal Gaynor.
Thank you very much.
All right, he is the victim's lawyer in the